We perceive no merit in defendant's various challenges to county court's denial without a hearing of the motion to withdraw his plea. The decision to permit withdrawal of a guilty plea is a matter within the trial court's sound discretion, and a hearing is required only where the record presents a genuine question of fact as to its voluntariness. See where the grounds adduced are facially without merit. No evidentiary hearing is required. We reject defendant's claim that a hearing was required here to explore how his emotional state may have affected the voluntariness of his plea. In reaction to Kahn's statement that the proceedings were of a deeply emotional nature to defendant, county court questioned defendant extensively during the plea colloquy regarding his mental condition. Defendant answered that while his emotional state, apparently angry and depressed, may have led to the commission of the offenses charged, he understood the criminal proceedings, was aware of the consequences of his plea, and did not claim to be not guilty by reason of mental disease or defect. Also, lacking in merit is defendant's argument that his assertion of innocence shortly after the plea allocution necessitated a hearing on his motion. Defendant's sworn statements during the plea colloquy reflect that he knowingly, voluntarily, and candidly admitted committing the crimes. His subsequent protestation of innocence, unsupported by any evidence beyond his own affidavit, is insufficient to warrant a hearing on the issue. Similarly, unpersuasive is defendant's argument that a hearing was required to assess his claim that Kahn fraudulently induced his guilty plea by misrepresenting the possible prison sentences. Despite having the assistance of substitution counsel and an opportunity to substantiate this claim, defendant again produced no evidence other than his own conclusory and self-serving affidavit. See People v. Carr, Supra, at 562, 732, People v. Carr, New York Supplement 2nd, 453. Although defendant now proffers a supporting affidavit of another person, we note that it is not part of the record on appeal and was drafted approximately 1 year after his sentencing, despite the apparent availability of the affiant at the time the motion was made. Defendant next contends that his plea was not voluntary or knowing because county court's statement of the sentences that could be imposed was ambiguous. The record reflects that after initially rejecting a plea offer, defendant decided to plead guilty after Kahn informed him that the trial judge could not remember over-imposing consecutive sentences on a plea to a multi-count indictment. During the plea colloquy, however, county court told defendant that the court's sentencing history was not provided to induce a guilty plea, but solely to the extent you deem it relevant. Most importantly, the court advised defendant that it was not making any commitment or promises whatsoever regarding sentencing, that the maximum terms of imprisonment were 4 years on each of the 3 contempt charges and 1 year on the assault charge, and that the court had not decided whether the sentences would be consecutive or concurrent. Defendant acknowledged this information unequivocally, since the record demonstrates that county court adequately advised defendant of the potential maximum sentences and that he thereafter entered a knowing, voluntary, and intelligent plea. We find no abuse of the court's discretion in denying the motion without a hearing. Finally, defendant contends that county court abused its discretion in imposing consecutive sentences. As this court has previously recognized, the imposition of the sentence rests within the sound discretion of the trial court, and we should not interfere unless there has been a clear abuse of discretion or extraordinary circumstances. County court here sentenced defendant to concurrent prison terms of 1 to 3 years for 2 of the criminal contempt convictions, a concurrent one-year term for the assault conviction and a consecutive term of 1 to 3 years for the third criminal contempt conviction. These sentences were appropriate considering defendant's history of stalking and abusing the victim.
Geez, my wrists are hurting. I kind of want to quit already. Seriously.
You couldn't get it?
Did you hear what I